Good afternoon, everyone, and welcome to the third in our series of webinars with our legal partner, A&L Goodbody. The number of members joining us for the first two webinars on employment law and directors' duties have been really encouraging. Feedback from those first two events have been really strong, with both receiving over 95% in our member satisfaction score, as well as lots of really positive comments on our post-event survey. For anyone who does want to catch up on those first two webinars, you can do so on our website, charteredaccountants.ie/Ulster. Today's webinar is an important update on GDPR and data from Aisling Byrne. Aisling is a partner in the A&L Goodbody Employment and Incentives team and has over 20 years experience in advising on employment and equality law. Aisling specialises in data protection law and she is Certified Information Privacy Professional Qualified. She delivered extensive training to businesses on implementing GDPR and since then has advised on a broad spectrum of data protection issues, including data breaches, data protection impact assessments, data subject access requests, and data sharing agreements. Today, Aisling will provide a brief overview of the latest developments on GDPR, data, and EU exit implications. Please feel free to put your questions for Aisling into the Q&A box at the bottom of your screen. The Q&A is open now, so feel free to type away. Please keep these questions general. However, Aisling cannot answer specific legal queries during the webinar, but we will give you Aisling's contact details should you wish to contact her directly with more detail. So we have a lot to go through, so let's kick off, and I'd like to welcome Aisling Byrne. Aisling.
Thank you, Maeve. Thanks for the introduction, and thanks everybody for joining me this afternoon. We're really just going to go through a whistle-stop tour of GDPR and data and look at the developments that have happened over the last year. So I'm an employment and data partner in A&L Goodbody. I started off in employment, but given the developments in data and the interrelationship with the employment arena, I quickly discovered that it would be good to develop a specialism in data. And you'll see on the screen, we have Elizabeth Denham. Some of you may recognise her. She's the current Information Commissioner in the UK, coming to the end of her 5-year term. But you'll see the quote that she made recently in October 2021, which is basically along the lines of, data is not an academic exercise. It basically permeates every aspect of our lives, which I think explains why we're all here today. What we're going to do today is just do a quick recap of the current data protection regime. I know everybody was essentially fatigued after the introduction of GDPR in 2018, but it hasn't gone away. And we'll come on to look at that when we think about Brexit and the impact on the data sphere. I'll then look at the Adequacy Decision, which has been granted by the EU. Moving on then to look at hybrid working and the data implications of hybrid working. Then moving on to look at some of the recent ICO fines and think about any learnings and things that we can take away from that. And then finally look at the UK government's consultation on reforming the data arena. So if we start with the data protection basics, I think we all know what personal data is. It's anything that relates to an identifiable human being. It doesn't relate to people who are deceased, and processing is one of the key terms that you'll see under GDPR and the Data Protection Act, and that relates to anything that you do in relation to data. So even if you're doing nothing, even if you're just holding data, you are nonetheless processing it if it's in your possession or under your control. A data processor is a person or an entity that processes personal data on behalf of a controller, and a controller is an entity that determines the purpose and the means of processing. And all of us essentially are data controllers, whether that be holding client data or data in relation to our employees. And under GDPR and the Data Protection Act, there are quite onerous obligations on controllers in relation to what we do with that data. You're probably all familiar with the general data protection principles. I'll run through them quickly. The main one being that we process data lawfully, fairly, and in a transparent way. There's a purpose limitation requirement, and essentially what that means is that we only use the data for the purpose for which we collect it. Data minimization means that we only hold the data that we absolutely need. And really the theory behind that is that the more data we hold, the more risk there is. And so if we confine our data holding to data that we absolutely need, then there's less risk in relation to how we use or hold that data. Data minimization, again, limit the amount of data we hold. Accuracy relates to the fact that if there's an issue in relation to the data, a data subject can approach us and ask for that to be corrected. Storage limitation means that we only give access to data to people who actually need to be able to see it and use it. Integrity and confidentiality, again, means that we preserve that data, and accountability is the final data protection principle, which didn't actually appear under the old Data Protection Act of 1998. It was a new requirement introduced under GDPR and currently under the Data Protection Act of 2018, which applies in the UK and extends to Northern Ireland. So as I say, accountability is this key requirement that we now have, and that's demonstrated through the requirement to ensure that we have data sharing agreements in place, that we have data protection policies in place, that we can show to the Information Commissioner if required that we have given privacy notices outlining to data subjects what we're going to do with their data. There's also a requirement to keep records. And I suppose it stands to reason that the only way that we can show that we're accountable is that if we keep records to show what we've actually done with the data. You'll all have seen the privacy notices, even as a data subject in our own right. We'll have seen when we use services or we access websites that there are privacy notices outlining to individuals how we use their data. And you in your own line of work will be issuing data notices to data subjects whose data you use, and you'll outline what you do with that data, the legal basis for holding that data, information on retention periods, and if you transfer that data to other entities, how you do it and why you do it. I've mentioned record keeping, and it is an important part under GDPR. Article 30 sets out a requirement to keep records, and that's something that the Information Commissioner looks at closely in the event of any data breaches or complaints to the ICO. And so we go back to the idea of always having a paper trail, whether that be a physical one or an electronic one, to show that we are data protection compliant, that we've conducted our audits, that we've issued our privacy notices, and that we're holding our data carefully and in line with our retention periods. Data subjects obviously now have more enhanced rights under GDPR and the Data Protection Act. They have the right to data portability, the right to restrict processing, but probably the most important of these rights, and I'll come on to talk about it, is the right of access. And we've seen this being used increasingly as a tool for people not necessarily just wanting to know what data is held by an organization, but more and more often in relation to a dispute. So for example, in relation to employment disputes, if individuals have a dispute with their employer, they'll very often issue a data subject access request just to see whether there's any information being held by the employer that might be useful, or in relation to other litigation. We've seen individuals issue data subject access requests even before you get into a litigation process where you've issued court proceedings, and it's a very useful discovery tool. Sometimes it's abused by individuals, but it's something that we now all have to comply with if we are data controllers. There's a lot of confusion very often in relation to the legal basis for processing. And this goes to the data protection principle of lawful processing. To process data, we need to have a legal basis to do it. And you'll see the legal basis outlined on the screen. There was a bit of confusion when GDPR was introduced, and a lot of organizations felt that they needed a data subject's consent to process data or hold data, and that's not always the case. And in fact, if you can find another lawful basis to process, that's very often better, because there are issues in relation to using consent to hold or use data The first issue being that an individual has the right to withdraw consent, and that has to be very easy to do. So if you can find another basis for processing, then very often it's better to do that. If you have a relationship with the client, you'll often rely on the performance of a contract. Or, for example, if you are processing an employee's information in relation to payroll, and you're passing that information on to HMRC, for example, you'll be processing that data in compliance with the legal obligation. So you won't always need to rely on consent. Protection of vital interests is a ground probably not used very often, and that's where you need to access or process data in order to protect someone's life. Public interest is a ground that's relied on by public authorities, and legitimate interests is very often the catch-all. So if you can't obtain consent and you can't find another lawful basis for processing, you'll very often rely on legitimate interests. The difficulty with legitimate interests is that you have to balance that against the rights of the data subject. And the UK government has announced some proposed changes into using legitimate interests so that it's easier for organisations to be able to use legitimate interests as a ground for processing. That's probably welcome news for a lot of data controllers and processors, and I'll talk about that towards the end of this session. Security breaches, again, one of the biggest issues that we see with organisations. You know, a breach can happen very easily. I don't think any organisation would be honest if they said that they hadn't suffered some form of data breach. Not every data breach will be notifiable to the Information Commissioner's Office, the ICO. The ICO oversees the data legislation, and every notifiable data breach must be notified to the ICO within a 72-hour window. Now that 72-hour window the clock starts ticking when you become aware of the breach. So there is an obligation to act quickly. If a data breach happens on a Friday afternoon, for example, the clock starts ticking straight away, and so the fact that it runs over a Saturday and a Sunday doesn't matter in the eyes of the ICO. The threshold for reporting, again, there can be a lot of confusion as to when to report or when not to report. And the test is whether the breach is unlikely to result in a risk to the rights and freedoms of data subjects. So you report unless the breach is unlikely to result in a risk to the rights and freedoms of data subjects. And that is a weighing up exercise that you need to perform as the data controller. If we take the very common example of an email being sent to the wrong recipient or group of recipients, and I'll come on to talk about a recent example of that where the organisation was fined. If, for example, an email containing personal data is sent to the wrong recipient and it's either immediately recalled, or you notify the recipient that it's been sent in error, they confirm that they haven't accessed the personal data and they've irretrievably deleted that information from their system, then you might reach a conclusion that there isn't a risk to the rights and freedoms of the data subject, in which case you wouldn't need to make that notification of a breach to the ICO. The ICO, I think, has found that a lot of organisations will over-report, which is why, again, they're proposing some changes to the reporting regime under the data protection legislation. I think the ICO has been so inundated with data breach reports that it's meant that it hasn't been able to get to the heart of really serious breaches, because it's spending so much of its time dealing with minor and low-level breaches. And I'll come on to talk about one of the proposed changes is that there's a threshold introduced for breaches, so that there needs to be some sort of material impact on the data subject to justify a notification. And also a requirement for the data subject to go through sort of a complaints mechanism process with the data controller before even going to the ICO. And again, I think that's to cut down on the level of reporting that's been made to the Information Commissioner's Office. I've talked about what you need to consider, and the test being whether there's a risk to the rights and freedoms of the data subjects. And what you will essentially look at when you're reaching a decision is the nature of the breach. Obviously, the more sensitive the information that's disclosed, perhaps the more likely you are to make a notification. And so if the data that's been breached contains, for example, special category data, which is the new term for sensitive personal data, and it's data in relation to health, trade union membership, religion, etc. If the data contains that type of special category data, then you might be more inclined to notify the ICO. And again, look at the consequences for the individuals. Again, that feeds back to the type of information that's been breached. If it's likely to have a serious impact on the individuals. If it was just, for example, a name and an address, you can see how, okay, it's a breach of personal data, but it doesn't contain sensitive personal information. And also look at the number of individuals affected. Obviously, the greater number of individuals affected, the less control you have over the issue of risk involved. A question that's also asked is whether you need to actually notify the data subjects themselves in relation to a data breach. And you only need to notify the data subjects if there's a high risk to their rights as data subjects. So that's the test that you need to apply. I've talked about data subject access requests, and again, that would be one of the other most used tools under GDPR and the Data Protection Act of 2018. And as I say, it can be used by individuals. You don't really need to outline your specific reason for wanting to see the personal data. And it can be problematic for organizations, particularly, for example, in the employment arena, where you have someone who's worked for an organization for a very long time, 10 or 20 years. You can imagine that the data that's been held by the organization is very voluminous. There'll be a huge amount of data that you'll have to go through because, there's a very tight time scale. You, strictly speaking, need to provide the data to the data subject within 1 month of the request. Now, that timescale can be extended in the case of a complex request. And if you're looking at a request that dates back years, then you can certainly argue that it's a complex request and that you can rely on the extension for a further 2 months. What you do need to remember to do is that if you are going to rely on the 2-month extension, that you will actually notify the data subject that you're going to rely on that extension within the 1 month period. So it's not okay to wait 1.5 months and then notify the data subject that you're going to extend time. You must notify the data subject within the 1 month period if you are going to rely on the 2-month extension. A problem for organizations when they're dealing with data subject access request is that very often the information will also refer to other data subjects who have their own rights as individual data subjects. And so you will need to redact that information relating to other identifiable data subjects. And that can be a very time-consuming and costly exercise, which again, I think is a rationale for the government's proposal to make a change in relation to data access requests. And the government is proposing to reintroduce a fee. There used to be a fee payable of £10 under the Data Protection Act 2018 in relation to data access requests. It was abolished by GDPR and the Data Protection Act of 2018, but the government announced a consultation process in September of this year, and one of the proposals is that they will introduce a fee along the lines of the fee that's payable under the Freedom of Information Act. And that might act as a deterrent for some individuals who are simply using the data subject access request process as a fishing exercise or as a tool to help them in litigation. If you're holding information that relates to a third party or that you've obtained from a third party, you still need to include that within your data subject access request response. And when you're going back to the data subject with the information, you also need to give them additional information such as the retention period, the reason for you processing the data, and their data subject rights and their right to make a complaint to the Information Commissioner. So it's not simply a case of providing them with the information. You also need to confirm that information, usually in some sort of a covering letter or an email. And if they make the request via electronic means, then it's assumed that you will make the response via electronic means. And certainly that's very often a lot easier than producing bundles of paper. But if the data subject requests a paper copy of the information, then you should provide that to them. So this is just a recap. It's a 1 month turnaround time. Sometimes the difficulty can be in spotting a data subject access request. We've seen situations where it's been embedded in the body of an email, raising complaints or referencing other things. So that's where data protection training comes into play, so that staff will be trained in relation to how to spot data subject access requests. Most organizations will have some sort of procedure in place in relation to how that will be handled and who will handle it, because in bigger organizations, you'll obviously have to involve a number of stakeholders, whether that be IT, HR, and in some bigger organizations, the legal department. Technology will be key in large scale data subject access requests, and how you leverage that to make the process easier, particularly in relation to redaction. Physically redacting papers with a black marker is a very onerous and time consuming process for an organization. And so if you can avoid that through the use of technology, then certainly that's a better option for you. Also looking at whether you actually strictly need to provide the information at all. In some situations, you'll have legally privileged documentation that you won't be obliged to provide. And obviously the DSAR only covers information up to the point that the request is issued. So anything that's created beyond that date, you won't be required to provide. Moving on then, just to have a look at data post Brexit. Obviously, Brexit has impacted on many pieces of legislation across the UK, but we implemented GDPR through the Data Protection Act 2018. So GDPR is here to stay. It's embedded in our UK legislation, which applies in Northern Ireland. And we now have what's called UK GDPR, which was introduced in January 2020. And so we merged that with EU GDPR. So when we're talking about the data protection legislation in the UK and Northern Ireland, we talk about the Data Protection Act 2018 and UK GDPR. But obviously, if you are processing the data of EU residents, then you must comply with EU GDPR, and you must think about appointing an EU representative and identifying a lead supervisory authority within the UK, and that would be the equivalent of the ICO that we have here. The ICO in London governs data across the UK and so covers Northern Ireland. There's been a lot of talk about data adequacy, and the UK confirmed immediately that it recognised all of the EU jurisdictions as adequate for data protection purposes. But we waited on a data adequacy decision from the EU, and that was essentially the EU weighing up whether it felt that there were adequate protections within the UK for EU countries to continue to transfer data into the UK. And we got that adequacy decision on the 28th of June, 2021. And so that preserves the data flows from the UK to the EU and vice versa. So there's no change in relation to that. all the data flows can continue. There is one point to be aware of, and that is that data adequacy is granted for a certain period of time. And so the expiry date for the decision issued by the EU to the UK expires on the 27th of June 2025, unless extended. And there is provision for the EU to monitor that during that period. So from 2021 to 2025, the EU will be looking at the UK data protection regime to make sure that we're not diluting any of what they see as the core data protection rights granted under GDPR. And when we come on to look at some of the proposed changes that the UK government are going to introduce, I think the EU will be looking closely at what we are intending to do, just to make sure that we are still adhering to GDPR. Hybrid working is now a way of life for all of us, but with that brings some data protection dangers and risks, and heightens the need for everybody to be very conscious of what they're doing with physical data, but also with electronic data and computer and IT security. I use this example on the screen to show that everybody's impacted by data issues and risks with hybrid working. And this example was a solicitor called Lucy Crossman, and she lost an unencrypted USB stick containing confidential client information. Now, it contained a substantial amount of client information. You'll see on the screen that 1,400 current and former clients were impacted by this. It was found by a member of the public, and they accessed the USB, saw some reference to her employer, contacted her employer, and they then immediately became aware that this was a data breach issue. The USB had got into the hands of a member of the public. I don't think the individual solicitor was even aware that the USB had been lost. She was on furlough at the time. So you can see how COVID has impacted on the world of work. And it really, I think with people moving from the office to home, there will very often be more transfer of data outside the office environment. So either that with physical taking home of files, or taking USB sticks or computers. And the key in this example, of course, is encryption. If the USB stick had been encrypted, then there wouldn't be this major breach issue that her employer had to notify to the ICO. So it's really just making sure that your technology is up to date, but also that your employees and staff are trained to ensure that they don't do anything that compromises your data when we are in this sphere of hybrid working. Another very, very unfortunate example related to a very senior civil servant who left files at a bus stop in England, and this was reported on in August 2021. Again, a member of the public found the files which contained 50 pages of classified MOD documents, and the documentation was highly sensitive. It was on pink paper, which meant that it shouldn't have been removed from the office environment at all. And it was found by a member of the public, leaked to the press, and the civil servant, he was on track to become a NATO representative for the UK government. So he was a very senior, he or she, I don't know which, was a very senior member of the civil service. And I think this example demonstrates that everybody can be involved in a data risk issue, no matter how senior you are within the organisation. And it highlights that I know a lot of the very serious data breach issues have related to electronic data, but there's still an issue in relation to physical data and files being left places in that transfer of information from work to home and vice versa. Some of you may have seen another data breach issue closer to home, and that was reported on earlier in the week. And that involved, I think, the Belfast Health Trust information was found in a desk, I think, that had been sold and not emptied. And I think that the information contained within that was sensitive personal data. And again, that was a data breach that had to be notified to the ICO. So again, there are issues in relation to physical data. So the tips in relation to hybrid working, they're all pretty much common sense, but data protection training is key, so that even if there is a data breach issue, you'll be able to demonstrate to the ICO that you've had refresher training and you've rolled that out to your staff. And it goes back to the accountability principle under GDPR on data protection. Having records to show that you've at least attempted to comply with your obligations will go a long way, and it could mitigate the level of fines issued. And we've seen that in cases, where an organisation has been able to show that they've taken steps, either that be through training, policies, procedures, to mitigate the damage in relation to any breaches, then it has been helpful in terms of minimising the fines issued. Investment in technology is key, using encryption, as we can see from the USB stick example. But again, multi-factor authentication in relation to accessing laptops, permitting only employer-owned devices to be used. And I know there is a temptation, if, for example, you can't successfully access your work system or your work laptop isn't working, there obviously is a temptation to use personal devices. That really should be avoided if possible, because that in turn then compromises the security of the employer's data. The data being left at the bus stop shows that there are still risks in relation to travel from work to home and vice versa. And I think pre-COVID, there was perhaps less risk because there wasn't this focus on hybrid working. I think people working on a hybrid basis are more likely to bring information home with them, whether that be to work on it at home the next day or bring it back into the office when it's marked up. And obviously, physical data is more at risk of being left somewhere where it shouldn't be. And so if that can be avoided and highlighted to staff, I think that's really important. And also then, the fact that we're still working within the 72-hour window to notify data breaches. The 72-hour reporting requirement hasn't been relaxed. None of the requirements have been relaxed. I think the ICO initially tried to help organisations in the face of very challenging data circumstances when COVID hit, but they haven't made any changes to the 72-hour reporting window. So that still needs to be complied with. And in terms of training, that is something that should be reinforced with employees. It's always useful to look at the fines issued just to see where the ICO is going and what their thinking is in relation to fines. And certainly in the 2021 year, there was a huge increase in fines issued by the ICO, 1,580% increase in fact, and £42 million worth of fines were issued in the 2020-2021 financial year. A lot of those fines related to nuisance calls, but the biggest fines related to breach of GDPR and the Data Protection Act. You probably read about these very large fines in the media. Now, the British Airways and the Marriott Hotel fines were reduced, and one of the reasons for the reduction given by the ICO was the fact that both businesses were facing very challenging times in relation to the pandemic. And so the pressures on the business were recognised by the ICO as being a factor, and they reduced the fines. That said, they were still very significant, 20 million and 18.4 million. But you'll see the amount of data that was compromised on the screen. The British Airways data breach involved nearly 500,000 customers. And again, the Marriott Hotel example, 339 million guests. So a huge number of data subjects were impacted by these breaches. hence the very high level of the fines. Hopefully none of you or your clients or organizations that you deal with would be dealing with breaches that involve this number of data subjects. But if we look at some of the other fines that were issued, these fines may be more relevant to the size of the organisations that we're all dealing with in Northern Ireland. Both of the examples that I'm going to talk about referred to charities, unfortunately, but both organisations were fined, even though their income was relatively small. And the first example is Mermaids, and this is a UK charity that offers support to gender diverse children and their families. The CEO of this organisation set up an internet email group in 2016 to exchange emails with the trustees of the organisation. But whatever way he'd set up the email group, the default settings made the messages publicly viewable via a search engine such as Google or Yahoo. So a mother was contacted by the Sunday Times in 2019 to advise that messages relating to her child were viewable online, and the information contained sensitive or special category data relating to the child's mental and physical health. So a very serious issue for the data subjects involved, and you'll see that 550 data subjects were impacted by this issue, 4 of whom were children, and the information related to special category data in the case of 15 data subjects. So obviously this was an issue that wasn't done deliberately by the CEO. Whenever the CEO was made aware of the issue, they immediately rectified the problem and made the notification to the Information Commissioner's Office. So they took all of the steps that they needed to do to notify within the 72-hour window. But nonetheless, the data of all of these people was seriously compromised. The ICO did take cognizance of the fact that Mermaids had acted quickly to try and rectify the situation and is shut down the public accessibility of this information. But when they looked at the training that had been given, they said it obviously hadn't been sufficient to prevent this type of issue happening. And so they issued a fine in July of this year of £25,000, which mightn't sound like a massive fine for some organisations, but it's a very substantial fine when you're a charity. And we look at the entirety of the charity's income, it made up 2.8% of the charity's annual income. So a substantial fine, also a fine that resulted in widespread publication. And it attracted publicity to this organisation that it could very well do without. So, a charity that does very good work for children and families ended up being in the media for the wrong reasons. And that's very often the other issue for organisations. Not only are they dealing with the data subjects involved in the breach, but if it's reported and if there's a fine issued by the ICO and it's publicised, it can have serious reputational damage for the organisation. Moving on to the second charity that was impacted in 2021, HIV Scotland was involved in a data breach. Again, a very, very easy mistake to make, where an email to 105 people was issued without the blind copy function being used. So the organisation had intended to use MailChimp. It wasn't up and running by the time they issued this email. And unfortunately, the recipients of this email were able to identify each other, or certainly a large number were able to identify each other through their email addresses. And with that then came an assumption that could be made about the individual's HIV status, which is special category or sensitive data under GDPR and the Data Protection Act. So a fairly serious breach, albeit it was as a result of human error. And this happens every day in organizations across the world. Emails are sent to the wrong people, the blind copy function isn't used. But the ICO looked at the training that had been given. And although HIV Scotland rolled out annual data protection training, the ICO commented that the training was inadequate because it didn't stop this breach happening, and staff didn't really understand what was expected of them. And a fine of £10,000 was issued in October 2021. Again, this breach was reported widely in the media, so not a good outcome for HIV Scotland. A pretty hefty fine for a charity. Again, it pales into insignificance when you look at some of the BA and Marriott fines, but they're global organisations with huge annual income, whereas when you're looking at a smaller charity, an ICO fine can have a very serious impact on income and expenditure. Moving on then to look at the direction that data is travelling in the UK. I mentioned that the government issued a consultation document in relation to data in September of 2021. The title of this consultation was Data, a New Direction. And this is something that the government had been thinking about for quite some time. In December 2020, it announced its intention to look at the data regime and see if it could be overhauled. I think there was a belief that it was quite onerous on organisations, and I think the example given by the government was that there shouldn't be the same expectations of a hairdressing business as there would be for a global organisation. And I think there probably is some merit in relation to that idea, where every organisation, despite their size, has to be GDPR and Data Protection Act compliant. And in some instances, when you're dealing with very small businesses, the obligations can be very onerous. Hence, the government issued this consultation just to see whether some changes could be made to cut down on the red tape and to make things a little bit easier for organisations, but also to make the UK more attractive as a data centre. The consultation closed on the 19th of November, and the announcement in relation to the response is expected in spring of next year. But if we look at some of the key changes, now it is a very lengthy consultation document. It runs to 146 pages. So I'm not going to summarise the contents. You'll be glad to hear. But some of the key changes that could impact on organisations in this jurisdiction, I'll outline them. And the first one relates to data subject rights, which I've just touched on. And that's a proposal to introduce a cost so that when an individual issues a subject data access request, that there will be some cost involved in that if it's an onerous request for a business, and it'll run something along the lines of the fee regime that applies in a freedom of information request, which I believe is somewhere between £450 to £600 if it's going to be that cost to an organisation. Then a fee can be applied. We don't know at this stage what that fee is likely to look at, but it could act as a deterrent for individuals who are issuing a data subject access request, and they are very onerous for organisations. They are also proposing changes in relation to accountability, and that involves imposing a requirement that organisations will have a privacy management programme in place. Now, I don't think that's actually in reality going to involve a radical change, because most organisations have some form of a privacy management programme where you have policies and procedures in place and you monitor your compliance and you roll out data protection training. But for larger organisations who have a data protection officer in place, the government is proposing that that's going to be changed and that there's going to be a privacy programme manager who oversees the entirety of the data protection programme. They're going to remove the requirement to comply and complete data protection impact assessments, and that's DPIAs. And you're required to carry out a DPIA currently if you're going to introduce something that involves high risk processing. And so that is essentially an impact assessment. The government recognises that that's also quite onerous for organisations, so they're proposing to remove that requirement, and also raising the threshold for a breach to the ICO. Again, I've touched on that, unless there's a material impact on a data subject's rights, there won't be a requirement to notify that breach to the ICO, and many organisations will be thankful about that, because at the moment, there can be some ambiguity in relation to what you notify and what you don't. And the government's also proposing that individuals would have to go through a complaints procedure with the data controller before they even reach the ICO. So that will obviously impact on the 72-hour window. So there'll almost be an internal complaints mechanism for them and an opportunity to resolve the issue before you even get to the door of the ICO. And again, I think that's the ICO's way of, or the government's way of, cutting down on the administrative burden of breach notification to the ICO that they're seeing currently. The government's also proposing to reform the ICO itself. So it's going to change the internal governance within the ICO and its relationship with the sponsoring department. And then finally, I've mentioned legitimate interests as the catch-all lawful ground for processing, and the government's proposing to introduce a list of legitimate interests that can be used by organisations to simplify things for businesses and to make it clearer as to when organisations can rely on legitimate interests or not, as the case may be. All of these proposed changes are currently at consultation level, but it is likely that a lot of them will be introduced, and certainly the government's intention is to try and cut down on some of the red tape and make things simpler for businesses in 2022, hopefully with legislation to be introduced later on in the year. So watch this space and see whether all of these changes are going to be introduced or not, and maybe we'll run another seminar at some stage dealing with the changes if and when they are introduced. So that's really a whistle-stop tour of data today, just giving you an overview and an outline of some of the recent issues. If anybody has any questions now, Maeve, I'm happy to take any.
That's great. Thanks, Ashley. We've got some questions coming in here, but maybe just to kick off, how often should we run refresher data protection training, do you think?
Well, we've seen in the two charity examples that I mentioned, Mermaids and HIV, they both run annual refresher training, and certainly that would be the rule of thumb that most organisations follow, that you would undertake annual refresher training, but that everybody joining an organisation would undertake training straight away. So that would be part of the induction programme. But even with the examples that I talked about, the training is no good unless it's actually impactful and it relays to people what they actually need to look for. So I think the ICO, looking at the training that was actually delivered, found that it didn't actually give practical examples, you know, to the individual employees as to what they should and shouldn't do. So it's not only a case of running your training, it's making sure that it's fit for purpose and actually uses practical examples that your employees can take away and put into practice.
Yeah, it's important. How do we assess the duty to report a data breach to the ICO?
Yeah, I think I've touched on that, Maeve, but really the threshold is whether there's a risk to the rights and freedoms of the data subjects. And again, it's very difficult because that's a weighing up exercise that the data controller, the organisation or the business will have to weigh up. Now, I know of some organisations that will actually contact the ICO. They do have an advice line and they can be quite helpful. You know, so if you're really stuck as to whether you should report or not, you can contact the ICO on a no names basis and see if they would give you a steer. But the key in the test is risk. So as I say, if the risk can be contained very quickly in the immediate aftermath of a breach, you know, just because there's a breach doesn't always mean that it's notifiable. It still rests on this idea of risk to the data subjects if you can contain the breach. So if, for example, a laptop is lost, but it's found and you can actually run a test to show that none of the information on the laptop has been accessed and there is proper security settings in place, then although there's been a breach, you know, it might have fallen into the hands of somebody in the public. If they hand it in and you can make that assessment and conclude that nobody's data is compromised, then there's no risk. And I would say no need then to go to the ICO, because the ICO has found that people are actually over-reporting, which is why I think the UK government is proposing to change the regime altogether.
Okay. We have one in here. So Aisling mentioned that if UK companies are processing data of EU residents, you must comply with EU GDPR and appoint an EU representative. Can you expand on that a little?
Yeah, and I mean, I think that maybe that's something that organisations don't think about when they're working within the UK jurisdiction. So, you know, strictly speaking, under the legislation, you should have somebody within another EU jurisdiction that would be your representative, and that would be somebody that could deal with things like complaints or data breach issues, or liaising with the local data protection authority. It probably makes sense to, you know, the difficulty I think for organisations is that if they are operating across the EU, then which jurisdiction do you choose? You only need to appoint a representative in one jurisdiction. So I suppose if you had close links to the Republic of Ireland, for example, you might decide to appoint a representative there, because that might make sense geographically, and it might be an easier process for you, and you won't have the language barrier then, obviously. But it is a requirement under EU GDPR that many organisations don't even realise that they're obligated to comply with.
Okay. Well, that's great. Aisling, I think we're coming up to a close here, so let people have 5 minutes before their next Zoom call as such.
No problem.
Thank you so much. Just thank you for your time today and all the information given there today. It was really, really insightful. And thank you all for tuning in as well. So hopefully I'll see you all in our next event and see you soon. Thank you, everyone.
Thank you.